All rise.
Hearing in the appeals AM Somalia.
Mr. Gill, I'd like to raise one matter just before we begin, and that is the question of anonymity. In the case which I've been thinking of as AM number 2, it's been made quite clear that there is no need for anonymity anymore, and indeed there's a recommendation really that should be dispensed with. Are there reasons for thinking that it's necessary to protect the names of the other appellants? It may be convenient just to go on referring to them by initials, but for the writing of judgments, do we have to maintain anonymity?
My Lord, may I consider that position? But my immediate reaction is that in those cases which involve a refugee context,
Yes.
It might be appropriate to continue referring to them by initial, but in others, it probably isn't.
Yes.
But
Well, can you just bear that in mind, and perhaps later on in the course of the week we can be informed how the various parties stand on that matter. Thank you.
I'm grateful. My Lords, the representation is as follows. I appear with Mr. Collins in the case of AM number 1, and I appear with Mr. Bazzini and Mr. Slatter in the case of VS. Mr. Fordham, Queen's Counsel, Mr. Nathan and Miss Weller appear for SA and AM2. And Mr. Panic, Lord Panic QC and Mr. O'Ryan appear for MI. Ms. Cars-Frisk QC and Mr. Hall appear for the respondent. The arguments in relation to AM1 and VS are arguments which I propose, first of all, to put before you. Mr. Fordham then follow on points in relation to 281 construction, Article 8, and also the Article 14 points on on the second AM2. And Lord Panic will deal with construction arguments in relation to 317. The documents that I propose to have particularly at hand are the core bundle in AM1 and volume 1 of the authorities bundle, because they contain the statutory materials. So far as the issues are concerned, my Lords, your Lordships will be familiar with the issue as to whether third-party support is capable of being permitted under Rule 281 and 317. And your Lordships will have seen the Court of Appeal judgments, so I don't take time in order to go through that. We'll rely on the printed case as it is before you, but I will concentrate on certain points. The way in which I propose to deal with it is to first of all look at questions of construction, the approach to construction, then look at Rule 281 and 317, actually getting into the rules themselves, and then deal with AM's Article 8 appeal and the individual matters relating to VS. So far as the approach to construction is concerned, our position on that can be, I think, fairly shortly stated. And essentially it comes to this. We say that the rules are to be, firstly, the rules are to be interpreted according to their ordinary and natural meaning, having regard to purpose and context. Secondly, we say rules are to be interpreted so far as possible with the ECHR. And for the purposes of the Convention, of course, the rules strike the balance between, for the most part at least, between individual and public interests. But if a Convention-compliant reading is not possible of the rules, there will be a small minority of cases which can nevertheless succeed on a freestanding Article 8 appeal. But most cases will, however, be capable of being dealt with under the rules, provided they are properly interpreted and applied, having regard to their purpose, context, and an ECHR compliant reading. If that approach to construction is followed, or even if one simply focuses upon the precise words of the words themselves, we say that Rule 281 and 317 do permit third-party support. They don't rule it out. And the issue really is not the source of funds, but the reliability of the arrangement, so as to prevent the risk of recourse to public funds. Lastly, in an extreme case, it may be necessary to strike down as a rule if it gives rise to irrationality and absurdity, despite the approach to construction that I've set out, but we do not think that that is likely to be necessary here.
Yes.
So far as the statutory context is concerned, the statutory context begins in the Immigration Act 71, if I can invite the court to turn to that. That is at tab 2 of volume 1. Your Lordships will see section 1.4. Section 1.4 says that the rules laid down by the Secretary of State as practice to be followed in the administration of this Act for regulating the entry into and stay in the United Kingdom of persons not having the right of a vote shall, it's a mandatory obligation, shall include provision for certain categories of persons, including this at the end, dependents of persons lawfully here, lawfully in or entering the UK. So he's required to provide rules which, putting it colloquially, deal with, in particular, families, persons who are lawfully in this country, their families will need to be provided for. It's not restricted to that, of course, but that's what we're particularly interested in.
So you're assuming then, on reading, at least you're invited to assume in subsection 4 that there is somebody who falls into the category of a dependent of somebody who's presently in the United Kingdom.
Well, indeed, but the question of what is meant by dependent may be a broader question to be interpreted by a range of factors consistently with, and the Act must be read consistently with Strasbourg jurisprudence, and the concept of dependency is therefore a broad one. That concept of dependency must be a concept of dependency which is not capable of being restricted by the Secretary of State, but is a concept of dependency which, if the statute is to be interpreted in accordance with convention rights, has, as I've just said, to be a broad one.
I don't want to take up too much time at the very beginning, but it's subject to such restrictions as may be provided. So
indeed,
it is open to the Secretary of State to contemplate situations where a restriction would be appropriate.
Certainly, but that point about such restrictions is not trying to cut down the question of dependency in any way. What it is doing is generally saying that, of course, there'll have to be criteria and conditions and so on, which the rules will have to set out. But what we're concerned with we Parliament are concerned with, is to make sure you make some provision in relation to dependence. And when we talk about dependence, we have to have regard to our obligations under the ECHR to make sure that this statute is interpreted and indeed applied by you consistently with ECHR.
That is a very minor point, but I mean, dependence in this context is amply capable of including somebody who is in fact going to be totally a burden on the state. That's all
indeed,
you're saying. Absolutely.
Indeed.
I mean, but it doesn't carry the argument very far anyway.
It doesn't.
It's not going to limit you.
I'm not seeking to place any excessive
Fine.
burden on it. I just want to draw to your attention, since we're at the starting point. Then There are other parts of the statute, however, which do deal with the point that my Lord has just raised. Section 3.1 says that 3.1c, if given leave to enter or remain, it may be given subject to any or all of the conditions, and one of the conditions is, you see at the bottom of the page, C, a condition requiring him to maintain accommodation himself and independence of his without recourse to public funds. So the statutory purpose is coming through, that what we're concerned about is to ensure that you bring dependents together, but what we're also concerned about is that subject to such restrictions as work themselves out, and such criteria as work themselves out in the rules, that there is no recourse to public funds. And then 3.2 about the obligation to lay the rules before Parliament, which means that this is a parliamentary mandate that is being given to the Secretary of State, and that parliamentary mandate has to be carried out in accordance with the ways in which Parliament expected its the powers that it has given to be exercised. So far as the So far as this obligation is concerned, it is also, I think, not in any dispute at all. Certainly wasn't in the court below, and Lord Justice Laws basically accepted this point. It would be odd if the rules were when made by the Secretary of State, were not made with regard to his duty under the ECHR. He's a member of the executive after all. He's as bound by Section 6 of the Human Rights Act as anybody else. In making those rules, it would be odd if he wasn't actually bound by the ECHR in how he devises them. And the rules themselves carry this a little bit further forward, which I'll go through in a moment. The way in which the rules are set out is at tab 8. You'll see that at tab 8, volume 1, rule 2, also makes clear the immigration officers, as an all-star, will carry out their duties without regard to race, other religion, and in compliance with the provisions of the Human Rights Act.
I'm not sure. I didn't find this actually. I've got an introduction at page 2788 at the very bottom of the page.
2789 is about 4 or 5 lines on top. It's very small font.
Oh, I see.
Strange.
Very, very odd. So that's rule 2, is it?
Yes.
How bizarre.
No, it's not. Is it? Maybe.
It looks like a footnote.
Yeah.
Yes.
Yeah.
And the printing seems to have gone a bit awry.
Yes. But that's certainly the rule. So what one is getting is a theme that the Secretary of State will comply with his obligation to make rules which, so far as possible, are convention compliant, have restrictions, of course. Those who will interpret and apply them will also seek to do so in ways which are consistent with the Human Rights Act. Nevertheless, we accept that there may well be situations where the rules don't actually and comply with the with convention rights. They may be badly drafted. There may be actually lacuna in the rules. Now, in those sort of scenarios, those limited categories of scenarios, there will always be an Article 8 freestanding appeal that a person will have. But the fact that there is a freestanding Article 8 appeal doesn't actually tell us anything about what is the approach to construction of the rules. So one cannot use the existence of a freestanding Article 8 appeal in order to say that the rules themselves are rules which are somehow to be interpreted as if all considerations of human rights were within the rules.
I think the way it's put against you is, and I'm looking at the respondent's case at 46 and 47, that the rules are not required to guarantee convention compliance because there is, as I think you've indicated in your introduction, there's always an opportunity for a decision to be taken in the individual case to ensure that the decision is compatible with the rights. But one would be driving it too far, it's suggested, to find every solution of compliance solved in the rules.
I am not saying that the rules are required to guarantee compliance with the ECHR. What I'm saying is that the rules have to be interpreted so far as the language allows, so far as the ordinary natural meaning of the words allows, in a manner which is consistent with their purpose, and their purpose, we say, is to promote family life. They have to be interpreted consistently with the ECHR so far as possible. It may not be possible. So they're not required to guarantee compliance with the ECHR.
But you're not saying you can invoke Section 3 of the Act in order to distort the ordinary and natural meaning of the words, are you?
My lords, Section 3 doesn't directly apply to this set of rules, because but leaving that point to one side.
But I mean, are you saying that's the approach you should take? I mean, for all the world as if it did apply.
The Section 3 approach can be a robust approach. I'm not saying that it actually has to be as robust as in some of the House of Lords cases dealing with Section 3. What I'm saying is that that sort of thinking, that sort of idea, that so far as you can within the constraints of the language, you should try to interpret the rules in a manner which is consistent with the ECHR. Whether a Section 3 approach that you actually start changing the language itself.
So you're not contending that you should give them other than ordinary. You're not seeking an extraordinary or unnatural meaning for these words.
I'm not seeking an extraordinary or unnatural meaning for the words. What I'm seeking is an interpretation of the words which recognizes that they have to be interpreted consistently with the
There's been a principle recognized for 80 to 100 years that all legislation must be interpreted, if possible, to be in accordance with the international obligations of the United Kingdom.
That's all I'm saying. And there are cases mentioned in other parties' cases. I think one of the parties mentions case of Brent and so on. It's well established even before we got the Human Rights Act. Even before we got the freestanding human rights appeal in this context, one had to try to do that as much as possible.
Well, I don't think you need labour this point very much, Mr. Gill. I mean, it will become quite clear, I think, once we look at the language, what the area for debate is.
Yes.
And you're not singling out a word and saying, well, that word should be treated as meaning something different from what it would usually mean.
I'm saying I don't need to do that, and I'm not saying that.
Yeah.
And the words on their face, read in accordance with the approach that we've just discussed, are perfectly capable of accommodating third-party support in 281 and 317. And it may be that references to matters such as ultra vires may perhaps confuse the court below, and that may have been my fault, but if one leaves that to one side, I'm not actually saying that they're actually required to guarantee that compliance with ECHR rights, but they have to be read consistently with ECHR rights. That approach is an approach which indeed the Secretary of State himself has followed. Not only have we followed it for decades, I'm not sure whether one authority of AB Jamaica has been handed up to you, but it wasn't in the authorities' bundles. But
what's it going to tell us that we don't know already?
It simply sets out in paragraph 1 that before the 1998 Act came in, what the Secretary of State was doing was going through an audit of legislation, rules and policies and so on, in order to try to ensure that they were convention compliant. So what was being sought to be done was to was to bring that approach of compliance with the convention as much as possible into all aspects of governmental decision-making. Hardly, as Your Lordship says, dramatic, but what it does tell the court is that when one looks at the rules, one doesn't somehow, when 2nd of October 2000 come in, starts looking at the rules somewhat differently, just because there is now a freestanding Article 8 human rights appeal. The approach to construction remains the same. So,
yes. We're looking at a rule 281, for example, which, looking on at page 2932 to 3, was substituted with effect from the 5th of June 1997. So technically the Human Rights Act came into force, was enacted after this, but we know the approach, as Lord Collins has said, which has been well understood well before that. Yeah. Well, as I said, I don't think you need labour that point very much, really.
My Lord, and we know certain rule changes were made.
Yes.
Shortly before October, 2nd October 2000. Leave that to one side. In looking at the ordinary language, the ordinary meaning of the words, having regard to their purpose and context, the court is not looking at extraneous policy statements by the Secretary of State. The court is looking at the rule itself. So insofar as you may be invited to look at other policy documents relating to the Secretary of State, which suggest that the rule may have to be given a restrictive meaning, we say that's not the right approach. What one looks at is the rule itself, the rules themselves, because had the Secretary of State wanted to adopt a certain type of meaning to the rules, what he ought to have done, in accordance with this statutory manual, is to put his interpretation within the rules and have it laid before Parliament and give Parliament the opportunity to debate it. So insofar as Immigration Directorate's instructions are to be used, they're not to be used for that purpose. This point is made very clear in, if it needs any authority at all, in a case such as AI Pakistan, Volume 4, Authorities Control at tab 30, paragraphs 31 to 34. It may just be worth looking at that very quickly. This was a case in which the Court of Appeal were asked to interpret the rule relating to domestic violence and the methods by which the requirements of the rule could be proved. The method is structurally not all that dissimilar to the approach, the debate that you have before you. And what the court said in paragraph 31, this is my document, paragraph 29A4, should be construed as to further the policy of enabling persons whose relations have broken down permanently as a result of domestic violence for the end of the probation period to be granted indefinite leave to remain. Construction includes an African whose relation has in fact broken down as a result of domestic violence, including in a case by producing cogent rather than evidence, would defeat the evident purpose of the rule. The purpose is to specify what an applicant has to prove in order to qualify for indefinite leave during the probation period. Namely, relations broken down. It's not the purpose to deny indefinite leave to victims who can prove their case, but can't do it in the way the Secretary of State wants to do it. What's the overall purpose of the rule? 32. If it had been intended that the applicants could only prove that they have been victims of domestic violence by producing documents of the kind specified in the IDI, this could have been achieved easily enough in the rule. They explain that. And then in 33, another way of doing it would have been to state in terms that an application may only succeed if the applicant produces certain types of documents. In that way, it would have been clear that the decision as to what kind of evidence to require was taken out of the hands of the caseworkers. If it had been done in either of these ways, Parliament would have had the opportunity to consider the point when scrutinising the rule. It might not have approved a rule which took away from caseworker discretion to decide in a particular case what the evidence would require for the purpose of prior to 9A for discretion was exercised with acceptable review on appeal. And it says over the page 34. In view of the purpose of para 289A, and since para 4 does not clearly provide, the applicant may only prove the necessary facts by producing evidence by describing the secretary in the structural. It does not have that effect. And then attempts were made, let's say, the Secretary of State to say, well, Secretary of State's got a policy-making role, but those sort of arguments were rejected. 36. Policy consideration by the law institute do not shed any light on the true construction of the rule. And we say, applying the same approach, that so far as the rules are concerned in this case, they do not clearly exclude third-party support. Exclusion of third-party support for all the various reasons we've set out in our plaintiff case would actually be contrary to the manifest purpose of the rules. And there is no reason at all to take away from the decision maker in question, whether it be the ECO, the Secretary of State, or an immigration judge, the task of having to decide whether the particular arrangement, funding arrangement put before the decision maker is actually a funding arrangement that satisfies the rule having regard to its purpose. That is exactly what decision makers do day in, day out. That is what they've been doing and were doing for years and years before immigration judges adjudicators were doing with third-party support for years and years before the tribunal suddenly decided to start a line of tribunal cases which shifted that position. So it is it would impermissibly, unconstitutionally, we say, cut down not only the decision-making role of the relevant enterprise officer or the Secretary of State, but also of the relevant judicial body itself.
We get Rule 1 tells us, I suppose, what the purpose of the rules was. This is at page 2788.
Indeed.
So we're told he's made changes in the rules laid down by him as to the practice to be followed in the administration of the Immigration Acts. It's the very bottom of the page for regulating entry into and so on.
Indeed, that's the practice he's going to follow. And,
that tracks section 3 of the Act, doesn't it?
Yes.
yes.
So we read back into section 1.4 and section 3, little 2 in the subsection. It's little 3, is it? Little 2, without recourse to public funds.
Indeed, it reads back into section 3. It reads back into the point about recourse to public funds, and what the Secretary of State does in laying out in this introductory paragraphs of the rules is how he's going to apply he's setting out his position. He, in the interpretation paragraph 6, gives a lot of definitions. At the bottom of 2790 is we don't need to take time over it, but it's a detailed definition of what public funds means. And then, having set all that out, on 2793, he makes clear in 6A, for the purposes of these rules, a person is not to be regarded as having or potentially having recourse to public funds merely because he is or will be reliant in whole or in part on public funds provided to his sponsor, unless as a result of his presence in the UK, the sponsor is or would be entitled to increased or additional public funds. That sets out what we say is the central approach, central to the Secretary of State's policy, What he's concerned about is, and what Parliament is concerned about is, subject to such further restrictions as may be made by the Secretary of State and the rules, is bring together dependents, but do so in such a way that it doesn't actually create any additional burdens on public funds. We've said in our printed case that there was a ministerial declaration made in the late 90s to make this clear, that what we're concerned about is that there should be no additional recourse to public funds caused by the arrival of the foreign family member in the UK. Unfortunately, the ministerial statement isn't in your bundles, but it doesn't matter because it actually worked its way into the rule itself, and here it is in Rule 6.
The definition of sponsor on page 2791 seems to be neutral from your point of view. Is that right? It simply identifies the relative,
Yeah.
but it doesn't qualify in any way that might be relevant to our discussion.
Absolutely, absolutely. And that's 2791 in relation to an applicant seeking leave to enter, then defines as persons who they'll be. The rule that and here I'm now beginning to get into the central part of the case in relating to the points about construction. I'll at this stage draw the Court's attention to Rule 35, because this is something the Secretary of State raised in aid, but we'll need to come back to it when I make some further submissions in due course. What this is saying is that a sponsor of 2805, a sponsor of a person seeking leave to enter or variation of leave to enter or remain in the UK may, it's a discretion, may be asked to give an undertaking in writing to be responsible for that person's maintenance and accommodation for any period of any leave granted. And then it sets out that there may be processes of recovery and so on, if nevertheless, for some reason or other, may be thought to be pretty remote, bearing in mind all the other definitions in social security law which needn't concern us, that there is in fact a burden on public funds. In fact, the prospects are virtually nil, but in any event, even if there are those risks, there is a discretionary power to require an undertaking. How that'll work and when it'll work and when it may be relevant is something that I'll discuss in due course, particularly when I come to Rule 317. So far as the Rule 281 is concerned, that is at page 2932. I think there may be some little bits here and there cut off, I'm afraid. You'll see that this rule sets out the requirements to be met. Rule 281 on page 2932, the requirements to be met by a person seeking leave to enter the UK with a view to settlement as the spouse of a person present settled in the UK, or who is on the same occasion being admitted for settlement, are that they're married. Then it sets out certain other criteria, language, having met, and so on, intention to live together, none of which really matter for our purposes. Then at 5, the parties to the marriage will be able to maintain themselves and any dependents adequately without recourse to public funds. What it is important to note is that the rule maker was very capable of adding in a qualifying phrase, that is the qualifying phrase without recourse to public funds, but did not take the step of adding in a qualifying phrase such as, and without recourse to funds provided by third parties. It's rarely as straightforward as that on the reading of the rule.
Well, it is indeed as straightforward as that. I mean, you're not suggesting that if he had it, he couldn't perfectly permissibly have done so. You're not suggesting that that would have been outside his powers, are you?
I'm not saying it would be outside his powers, no.
Absolutely. But you're saying he didn't do it.
saying he didn't do it. And hence my comments at the start about the ultra vires, that we probably don't need to deal with that. It's not outside his powers. He could have done it, but he hasn't done it.
So Parliament, in effect, by not saying it, he hasn't given Parliament a chance to consider whether or not they would be prepared to approve it.
That's right. That's right. And Parliament would have naturally anticipated that the mandate that it gave in the Immigration Act 71 was going to be carried out in a manner which would be consistent, if insofar as I need this argument at all, would be consistent with convention rights. Don't actually need that argument, but that's what Parliament would have thought. Parliament would also have thought, if we're dealing particularly in Part 8 of the rules, and Part 8 deals with family members, what is the purpose of this whole idea of bringing dependents of family members together so that they can come be together in the country? Surely it is to ensure that family life persists, is allowed to take place in this country. That point is made amply clear in the case of M and A, which is in the volume 5, tab 42. I seem to misplace my volume. You'll see this was a case in which, volume 5, tab 42, in which the Court of Appeal was considering Rule 297, the children rules. They were considering the different wording of that rule. And
This is the earlier unamended wording, is it?
I don't think it's the earlier unamended wording, no.
I think it's the same wording as we're being asked.
Sorry, no, it's quite right.
Yeah,
It's the later
6,
wording. Yeah.
yeah.
It's the present wording.
Yeah, but what they're talking about there was the reason why I'm citing this is not for to make any point about difference in wording, but to show the approach that they took to construction. And at the discussion starts at paragraph 19, and at paragraph 21, it says this: but subject to these conditions, conditions being the reference above, one of those being without recourse to public funds, top of page 12. But subject to these conditions, the aim of the rule is clearly to bring families together and to keep children with their parents or other relatives until they become independent. The objective is also consistent with Article 8 of the ECHR. It seems that the narrow interpretation of the words accommodated adequately, the issue was not by the parent but accommodated adequately, is inconsistent with the object of promoting family life. This argument can, my lord, stand just as well without the ECHR. Unless compelled to do so by clear words, I would not impute to Parliament the intention to authorise or require the grant to children of indefinite leave to enter the UK to join their parents if they are likely to be subjected to serious abuse from their parents, even if the parents are able to provide them with excellent physical accommodation. Children who are abused by their parents may well have to be taken into local authority care. Such an outcome is both inimical to family life and involve the call on public funds. If this occurs, the objective of the rule to promote family life and to do so without recourse to public funds is plainly defeated on two counts. And then mentions, continues in that vein, and at paragraph 22,
Yes.
in my view, the question before this court should be answered by interpreting the language, by giving the words, the paragraph, their natural meaning in the context of the purpose of the rule. The language of Rule 297 does not require, and you'll recall the words in the other case that I referred to, IA Pakistan, does not require the adoption of the narrow interpretation. There's nothing which limits the factors which can be taken into account to the physical suitability of the accommodation, and therefore they took the view that if the accommodation was going to be inadequate for the child in other ways, such as an oppressive parent, that didn't fall within the rule either. Now, that approach to construction of the rules shows what must be, we say, plainly obvious, that Part 8 of the rules, whatever may be said about the other parts of the rules which deal with workers and visitors and other categories of persons, but Part 8, which starts on page 2931, is headed family members. And you see that it starts off with spouses and the whole structure of the rule and moves through children, adopted children, dependent relatives. It's all about bringing such persons together. And even at common law, there is a value that one promotes family life and one promotes rules which are rooted in that context in a way which will promote that family life, subject to such valid restrictions as may be imposed. And here the central one is the recourse to public funds. That being the case, we say that in AM's case, AM number 1, there clearly was an ability in the parties to maintain themselves and any without recourse to public funds.
I suppose in one sense it depends a little bit about how one construes these words, the parties able to maintain themselves. Supposing that you have let's say a young man, taking out of the immigration context, a young man who receives money from his father, and lives on the money which he receives from the father, would you say that he's maintaining himself, or would you say that he is being maintained by his father?
My Lord, in that context, the relationship is between parent and child. Maybe an adult child, but it's still that relationship. In that context, the child is looking to the parent is providing the money, and in that context, one may say that the child is being maintained by the parent.
I mean, you can change it. I mean, supposing he's getting the funds from his best friend or something like that. Would you say he was maintaining himself, or would you say he was being maintained by?
Well, my Lord, the argument in other contexts may be different, because if it is the case that X, this young man, is getting funds from another source, doesn't matter for present purposes who the source is, it's money that is in his hands. It doesn't matter where he gets the money from.
Just using it as sort of just the language, I mean, the natural use of language. I mean, I just wonder whether one would say that somebody who's getting money from somewhere else is maintaining himself or is being maintained by someone.
My Lord, even those words maintained, even that approach, being maintained by somebody else. If the words, for instance, I think what your Lordship has in mind, the words of Rule 297.
Yes, I'm just looking at the, talking about the natural meaning of the words. It doesn't immediately, I mean, I'm not saying it's conclusive, but it doesn't immediately suggest to me somebody who is being supported by somebody else.
Well,
it suggests to me these are parties who are maintaining themselves.
Well, my Lord, the words simply say here, the parties will be able to maintain themselves. Are they maintaining themselves? Answer, yes. How are they doing it? They're doing it from funds obtained through third parties. That second question is not the question. The question is, are they able to maintain themselves?
I mean, you say the parties here is manifestly husband and wife in this context. Are they able to maintain themselves means no more than are they able to keep body and soul together wherever the funds come from, whether it's his earnings, her earnings, a rich and indulgent father, or anybody else you care to mention.
Absolutely.
Is there anything to be gained out of the subparagraph immediately before that? That's little 4, dealing with accommodation. Because there is a qualification, isn't there? In accommodation which they own or occupy exclusively.
Well,
So, I mean, it wouldn't do if they were just simply living in somebody else's property as licensees or something of that kind, would it?
well, my lord, let me deal with that carefully. That, in fact, supports our construction.
Yeah.
Because what that is saying is that the accommodation must be either something that they own, that's fine, that's obviously going to be their own, but it is also saying that it may be something that they occupy exclusively. Exclusive occupation, as it is, as the court well knows, as it is dealt with in all these cases and has been for ever since this provision came into these rules decades ago, it simply means that they're able to occupy one room, which doesn't breach the overcrowding standards, and they have exclusive occupation in accordance with normal principles of landlord and tenant law.
So the terms of the tenure don't matter a bit, do you say? It's just the fact.
Absolutely, absolutely. In fact, those words, or occupy exclusively, point to the fact that third-party support was specifically permitted within the rules. Because had it been excluded, that reference would not have been in those terms. You can occupy something exclusively, even though you have no entitlement to it, you have no ownership to it. It may be taken away from you depending on the terms of the arrangement. Terms may be, landlord says to the tenant, you can occupy this room in my house, resident landlord, on certain terms, maybe even at nil rent. All of that is perfectly capable of passing the test of exclusive occupation. And
it's got to be on a long enough term basis to be able to ensure that it'll still be there as the time passes and this dependent spouse comes.
Oh, absolutely. Yeah. We don't draw back from that point at all. It's certainly got to be something that is going to be reliable, because this is looking to the future. There will be accommodation. If it's going to fall apart within a short period of time or after a foreseeable period, this rule may not be satisfied, but that's a question of reliability of particular arrangements. And a question of fact, which then has to be determined in each and every case, exactly in the way that immigration judges have been doing for decades. Why it was thought to be somehow difficult is in itself difficult to understand, because a policy decision seems to have been taken in a case called AA Bangladesh by the tribunal in 2005, 6 years after Mr. Justice Collins, in a case called Amal Ali, said third-party support is permitted within the rules. 6 years later, in AA Bangladesh, the tribunal say that, well, actually, these arrangements are too precarious, too problematic, and it imposes burdens upon adjudicators, immigration judges, and so on. And we say that is not the right approach to take in relation to the rules. If the case of Amal Ali was going to be backtracked from by the Secretary of State in some way, he had plenty of opportunities after 1999 to amend the rules and to say, notwithstanding Mr. Justice Collins's clear statements that third-party support is permitted under the rules, leave aside his references to ECHR, whatever one may say about that, he clearly concluded that third-party support is permitted. If the Secretary of State takes no action thereafter to actually modify the rules in any way, other than in relation to para 297, the rule relating to children, where he introduces the words by the parent, one may wonder, how can he possibly now say, under 281 and 3, or any of the other rules apart from possibly 297, that third-party support is excluded? There may have been particular reasons in relation to 297 to do with child protection, to emphasize child protection concerns. But even if those reasons be good reasons, they certainly are not reasons which apply to 281 and 317. My lords,
just help me with 317, because on its face, I mean, it seems to be perfectly capable of in fact, dealing with children also joining parents. I appreciate that they are altogether more specifically dealt with by 297, but actually, as I say, on its face, is there anything in 317 that shuts out children?
Well, 317, if I just take a moment to read that, requirements on 2959. Requirements to be met by a person seeking ILR as the parent, grandparent, or other dependent relative of a person present and settled in the UK are that he is related in a number of ways. One can be mother or grandmother, or widow, age 65 or over, or father, grandfather, or widower. Parent or grandparents travelling together, one of whom is over 65. And then D deals with a very specific situation of where a parent or grandparent aged over 65 has entered into a second relationship. But
I see. You get it. If you get into all the detail, you see that children don't come in.
Yeah.
Okay.
Well, at F, it says the son,
daughters,
the daughter,
over the age of 18.
Ah, yes.
Over 18.
297 is under 18.
Yeah, I see.
That's right.
Yeah. Anyway, but the fact is that none of our cases, in fact, we're concerned, in fact, with 297, as I understand it.
yes.
I mean, theoretically, 297 could have been in play in both SA, Somalia, and in MI and KA, but it hasn't been treated as if it is.
I think Lord Panic is saying that it's really dependent on 317 in MI's case.
Well, that's how it's been treated. It's 317 in that case, his case, was treated at all stages below as covering both.
Lord Brown's point about the meaning of maintained would apply equally to 297.
My lord, that's right. And we say that so far as 317 is concerned, at 3, it says that the person should be financially wholly or mainly dependent on the relative present and settled in the United Kingdom. That simply doesn't begin to say how it is that the relative should actually discharge or satisfy that dependency. It doesn't begin to say anything about whether the relative in the UK should be doing so from its own funds or whether it's monies, gifts received from somebody else.
But are you taken back to that point by 4A?
4A, yes.
Because you have to read them all together, don't you?
Yeah. It says, can and will be maintained adequately together with any dependents without recourse to public funds. And 4A is looking to the future. Can, at present, will be maintained adequately together with any dependents without recourse to public funds.
So the phrase, or rather the word themselves, which we saw in 284,
Yeah.
and in 281 actually as well, doesn't seem to be in 297 little 5 or 317 4A.
That's right. That's right.
It uses the it uses will be maintained, it uses the passive form, whereas the other one talks about them maintaining.
Yes.
And you say there's no difference between, no intentional difference, you say.
That's right.
I mean, Lord Justice Carnwood felt able on 317 to say, okay, well, the others, he was bound by the earlier decision in MW Liberia, and there was no way out for the claimants there, but for 317 he felt able to distinguish on that pretty
That's right.
narrow difference in language.
That's right.
But I mean, you say, well, frankly, no difference between any of them. They're all perfectly all right.
That's right. That's right.
It's really a very short point on construction there, isn't it? When you're out
My
there.
lords, certainly, so far as Ms. Carr-Frisk's points are concerned, which attempt to explain this in some detail. I'm happy to try to deal with them now or deal with them in reply, whatever your lordships would prefer.
Well, I don't think you need to develop the points you're on very much further, really. I just want to be quite sure we've seen all the bits in the rules which could be relevant to the construction of the rule you're interested in.
Yes. I won't then go through a detailed critique of, if I can put it in that way, of my learned friend's points in paragraphs 58 and 63 of her printed case. But those points are not points which we say are valid points at all.
Sorry, what? 58 and 63?
58 and 63. Those are where she...
These are multiple points.
Yeah.
Well, it may be better to hear from Ms. Casfris before we go through this, because...
My Lord, I think that's probably right. Let me put it to one
matter.
side. It's always unfortunate when Council introduces reference to paragraph 58 and everybody feels tempted to open the book up. Perhaps I'll deal with it in reply. There is one point, however, that I do want to explain in relation to paragraph 317. One of the things that is said is in relation to this point about undertaking. We say that the undertaking provision in Rule 35 doesn't assist at all in the construction of Rule 317. Rule 317 itself says nothing at all about an undertaking. The requirements in Rule 317 that there be adequate maintenance, adequate accommodation, those requirements can easily be met without building in any requirements for there to be an undertaking. But there may be some circumstances where an undertaking is thought to be desirable. And we can see that. We can see that there might be some scenarios where a decision maker, such as an anti-clearance officer or the immigration judge, says, well, you have provided evidence that you are going to be funded by your relative, the relative that you want to join. But I am not wholly sure whether that arrangement with that relative is going to be precarious or not. I therefore want an undertaking from that relative. In those circumstances where there is some doubt as to the precariousness or otherwise of the arrangement, there may be a request for an undertaking.
That could be significant in a case of accommodation, in the kind of situation you were suggesting to us. A room in a house that's owned by somebody else, and an assurance that, yes, you can stay there if you like, that you want it to be put in on a more formal basis.
Quite.
Is that the sort of thing?
Absolutely, that sort of thing. But the undertaking in para 35 doesn't require any particular format. There may be a format, but it doesn't actually require any particular format.
Well, it's just in writing, that's all.
Yeah.
I'm sorry, just go help me. I mean, just assume that there it is, as a young man and wants to bring his wife in. He's got a rich father, and the rich father is saying, I want my daughter-in-law to come. Here it is, I can guarantee that, I'll give them $500 a month to make sure they're okay. Now, is there any way that the Home Office can get an undertaking off father?
Under the rules, the undertaking from the father can't be taken under the rules. But that doesn't matter, because the example that your lordship puts forward is a spouse case.
Is what?
Is a spouse case. Son wants to bring a wife over, or the other way around.
Yes.
It's a spouse. It's a
Quite.
281.
Spouse case, I'm sorry, yes. So therefore it doesn't fall within the rule.
It's not this rule, it's 281. And in 281, if somebody else is providing the funds, such as father,
Quite.
the focus of Rule 281 on its face, as with 317, is this arrangement going to be reliable, or is there going to be some sort of risk to public funds? That's all. If the arrangement is reliable, accepted on evidence as reliable, a perfectly genuine third party, in this case the father, perfectly genuine,
Well, I
reliable...
understand all that. All I'm asking is there any way of getting an undertaking? Not under the rule, but is there any, can you do it outside the rules or anything like this?
There's no reason why you shouldn't ask
Well,
for an undertaking outside the rules, but that's a matter of evidence. But it's not an undertaking under this rule.
No,
because
it's directed to the sponsor.
That's right.
So it doesn't relate to the father. It
That's
relates
right.
to the spouse.
But that's the only point in relation to this. But it doesn't mean to say that you can't look to see whether the arrangement being offered by the third party is a reliable one. If we go back to the rules, under 281 and 317, the focus, as I've said, is are there funds available? Source doesn't matter. Is it going to be capable of being used by the sponsor in order to accommodate support, maintain, etc.? And if there is some doubt about that arrangement, what an ECO may say is, look, you've provided this information from this third party, but I don't really think it's very good. If you're going to if this arrangement is going to pass muster, if this is going to satisfy Rule 281 or 317, whatever it might be, you're going to have to come up with something better than that. And when you go before the immigration judge may similarly say, well, this just isn't good enough. You're just coming along with a third party, dad just saying, well, I might give him money in due course.
I mean, they might make father produce an irrevocable authority and some commitment to the bank or something like that.
Well, that is the sort of thing that you get happening before immigration judges who will want to look to see how is this money coming forward? Is there a record? Is there a track record in the past of such money being offered? Or is it just being offered now? If it's just being offered now for the first time, why should we rely on it? What evidence are you going to produce that this arrangement is going to be reliable? Now, that is all capable of being dealt with under 281 and 317. In the Rule 35 thing is a red herring in effect, because what it is doing is providing a different form of it's a supportive mechanism for ensuring that in those cases where you think there might nevertheless still be some recourse to public funds, you're not sure about it, even though you've looked at the arrangement under 281, 317. You may then have to say, well, actually, we actually want a written undertaking from the sponsor, and that written undertaking will actually be then capable of being enforced against the sponsor if something were to go wrong.
And does the point remain then on your argument that the basis upon which the sponsor feels able to give that undertaking doesn't matter? I mean, the sponsor can feel perfectly relaxed about giving it if her father, for example, has already assured her that the money will be forthcoming, or the accommodation in which they propose to live is one which she can be confident will be kept available.
Absolutely, absolutely. It's
so
not
she makes the arrangements. She's in the UK and makes these arrangements as part of the preliminary to the application for leave.
She is no mere conduit. She is the one who's actually central to the whole thing. She is the one who's actually going to ensure that this arrangement works. It's in her interest to make it work because it's the family that she once brought over to be reunited with. She is no mere conduit who, if she were to drop out of the picture, the funding would still continue. that argument is particularly relevant for VS's case, where this whole idea about a conduit just simply seems to have been misunderstood.
Mr. Gill, is the sponsor in this situation undertaking that he or she will actually support the person, or are they saying, well, if the person gets into difficulties, then they will support them? Is it a sort of guarantee, or what is it? I mean, it talks about being an undertaking they will be responsible for that person's maintenance. I mean, does that mean that it's envisaged that the person will be wholly dependent on that fund, or is it just a guarantee if they get into difficulties that?
It is.
I mean, I know that long ago, when people were refugees, for example, coming from Germany and so on, they had to get sponsors, and these sponsors didn't have to say they were going to actually maintain the people, but what they did have to say was, if they got into difficulties, then they would step in and fill the breach. I just wonder. I mean, I just don't know what's envisaged here.
I mean, surely under 35, and the clue is in the last couple of lines, isn't it? I mean, what you're undertaking is to make sure that there isn't actually going to be any public funding necessary, and if there is, you pay for that additional public funding.
I mean, I can. That's exactly it. I mean, I can explain how this works in connection with the social security provision, but it's not necessary to do so. I mean, a spouse who under 281 is only going to get limited leave for 2 years to begin with anyway.
It's a basis, really, for taking action against the sponsor should something break down.
Yeah, that's exactly. It's a safeguard that should something happen where that very extreme category of circumstances, which only rarely arise in certain 317 indefinite leave to remain cases, that a liability arises is then forced upon the state. In those circumstances, the state wants to be sure that there won't be a burden upon public funds, so it asks that sort of undertaking. In practice, my lord, for those of us who practice at the coalface, sometimes undertakings are asked, sometimes they're not. It's pretty hit and miss. And it depends on when I say hit and miss, what I mean is it depends upon the reliability of the arrangements that are being offered. If the arrangements are reliable, under 317, there is no need for the undertaking. Under 281, you're never going to get an undertaking anyway, because a 281 person is never going to have recourse to public funds. There's a possible way in which 317 people could.
Sorry, what?
Although that gets into rather more complex questions of social security law, which is not necessary to go into. Perhaps I'm just pushing into areas
So
which
you never have a Rule 35 undertaking in the case of a spouse?
in practice it doesn't happen.
Well, maybe in practice it doesn't, but why can't you? I don't understand.
Well, I suppose you could, but what I'm trying to explain is in practice it doesn't happen because such a person gets limited leave to enter for 2 years to begin with, and because because a person only gets limited leave to enter under Section 115 of the Immigration and Asylum Act 1999, such a person is a person still subject to immigration control and therefore excluded from benefits anyway.
What about accommodation, though? Because the 35 undertaking extends to accommodation as well as funding.
Yeah, the exclusion from benefits, if I recall right, covers local authority housing as well.
Including homelessness benefits?
Well, that gets quite complicated, my lord.
Well, anyway, I mean,
it's not necessary to go into it.
We don't have to decide that case, probably, but I mean, to some extent, I should have thought it's perfectly self-evident that, I mean, if you're right, as you well may be, on the main point, I mean, the consequence is, as the respondent says, necessarily the assurances are more precarious, more difficult to verify, and because you don't have the Rule 35 mechanism available to you, more difficult to, so to speak, enforce by that route.
But that's a question of assessing the particular
I'm not
arrangement.
saying you're wrong, but I mean, I think you just have to face up to the fact that there are those consequences and that one could understand if the Secretary of State, you would say, chose to do what he hasn't already done, which is to make third-party funding as prohibited as public funding.
My Lord, I referred to the case of Ahmed Ali without taking you to it. Perhaps I should just take you to it. It's in volume 6 at tab 53. And you'll see that before paragraph numbers came in on page 103, the learned judge looked at page 102, I should say, at B, a confining for the construction of the relevant rules. He then sets out an approach which, even if one leaves aside the references to Article 8, is an approach which the common law, in terms of construction principles, can easily accommodate.
So no greater impediment than necessary to the ability of those settled in the country to enjoy family life here. That's his... is that right? It's just below letter B.
Yeah.
That's the passage you're directing our attention to, is it?
Yes. That's the approach that he took. But even if that approach, even if you think that approach goes too far in terms of ordinary principles of pre-Human Rights Act construction, nevertheless, the general thrust of what is being said here still is relevant. And he goes on at the bottom at G. Say, if a rich relation, he refers to the wording of 2816 does not in turn suggest the ability to maintain must be from the party's own resources. Other rules do. At F to G. Thus, for example, he refers to businessmen, visitors, and so on.
Yes.
And your lordships will have seen that point in our printed case. We make the point that other rules explicitly say, are very capable of saying, you've got to have the resources of your own. He goes on to say, if a rich relation or benefactor is willing and able to maintain a family in this country, so there's no need to have recourse to public funds.
You can't, as I say, you can't have a sponsor if you want to come in as an actor or an artist or somebody, can you?
You can still be funded by other sorts of
but
sure.
But the concept of sponsorship is confined to families.
That's right.
Can we just look at one of those rules, just because I haven't got a clear picture in my mind how it works?
201 is quite clear too.
Which is 201, shall we look at?
201 is very clear.
201, where do we find that back in our rules?
Volume 1,
2882.
2882.
882.
882, thank you.
Yes. So he's got to do various things himself.
It's not less than 200,000 of his own money under his control.
And that his share of the profits, I'm looking at little 9, his share of the profits of the business will be sufficient to maintain and accommodate himself. So it identifies the source from which the money is to come.
Yeah. Our point essentially is that these rules are perfectly capable of being very specific when they need to be.
What about actors and artists at page 2896?
How do they work?
Yes, it's from his own resources. He's got to be able to accommodate himself without working except as a writer, composer or artist.
Yes.
So it is much sharper.
Resources.
Where
2324.
Will be able to
maintain and accommodate himself
from his own resources. From his own resource.
Yes.
Yeah, that's your better one, isn't it? I mean, 201 is not very good, really, is it? I mean, it's not very helpful.
Well, it does make it clear that it's a share of the profits of his business.
Yeah.
It does identify the source
Yes.
from which the
That's
support
true.
is
No,
supposed
that's
to come, which you say doesn't appear in the rules we're concerned with.
And actually, he can't even get it from other employment.
No.
So,
They tie them down to the
Yeah.
purpose of seeking entry, really.
That's
I
right.
suppose
Yeah.
is the point where you say, well, that's fine in those cases, but in the case of family life, the purpose is to reunite the family.
Yes.
And one shouldn't therefore be too prescriptive about the means by which that is to be done, or the sources from which money comes, provided the golden rule about recourse or no recourse to public funds is observed.
That's absolutely right. And
but you point also to the conspicuous absence of the words from his own resources or from their own resources.
You can't have a rich patron if you're an artist.
perhaps
Strange.
I think perhaps the patron has to come up with the money up front.
My lords, in our printed case at page 32 at the bottom, a number of rules are set out. One of those is 2633.
Sorry, what page?
Well, if you look at page 32 of our printed
Yes,
case,
thank you. Yes, I see.
Yeah.
at the bottom we've set them out.
Yeah.
But the one that Mr. Fordham would particularly like me to take you to
Yes.
is 263. And that is on page...
Yeah.
The relevant bits are underlined on our
Resources,
page 32 of our printed case, but
Yeah, I
if
see.
you go to the rule itself on 2911...
Yes.
But then it's hardly surprising, given the purpose of the reason why he's seeking entry. He's claiming that he's a person of independent means. Isn't it? I mean, that's the heading
But
of the...
the point, the relevant point is, it is still capable of using the words with no assistance from
Yes, precisely.
any other person. You can be a person of independent means and say, well, I'm actually getting all my money from somebody else, so I'm a person of independent means. And say, no assistance from any other person. It's as specific as that. So when the rules want to be specific about the source of the funds, they are.
So that one, I mean, goes the furthest walk, because it not only says from his own resources, and says, of course, without having recourse to public funds, but it also says with no assistance from any other person.
That's right.
I see, yes.
Yes. Just going back to 35, the second paragraph of Rule 35 at 2805 does introduce the possibility of a criminal offence. So it reinforces, I think, your point that the sponsor is taking a particular position. And it's fair enough if a sponsor is actually taking the initiative in setting up arrangements that he or she should carry the can if they break down.
Absolutely.
It doesn't follow that you take anything out of the fact that you can't subject the third party to this kind of regime as well.
Yeah. Indeed so, my lord. My lord, the points on construction are essentially these, but on that last point, I was we were looking at Ahmed Ali, and at page 102, Mr. Justice Collins, this is volume 6, tab 53, at 102, letter F. Mr. Justice Collins was looking at these rules, and at G, he referred to the rich benefactor example. He looked at 297, the previous wording before the rule change, at the bottom. It says the natural meaning of 297 enables a child to seek leave to enter joint relative, where, for example, his parents are residents here and the relative, rather than the parent, may maintain and accommodate him under 2974. Now, that was the approach to the unamended Rule 297, and that is the approach you should take. We submit to 281 and 317. at the bottom, at F, is conscious of the need to not do total violence to the language, but then says at H, I do not doubt that it will be rare for applicants to be able to satisfy an ECO, the Secretary of State, or an adjudicator that long-term maintenance by a third party will be provided so that there will be no recourse to public funds. But whether or not such long-term support will be provided is a question of fact to be determined on the evidence. The adjudicator in this case was so satisfied, and there was evidence which satisfied her in reaching the conclusion she did. And we say if there are concerns about the arrangement put forward, they won't pass, even before one gets onto issues of whether the state's interest should be underpinned by the need for a maintenance undertaking, which then, in those cases, will expose to liability to civil and criminal sanctions. My Lords, the points on construction, therefore, are largely those. Some other points that are referred to in our printed case, which I hope I can just take by simply referring to the printed case itself.
Just before we get that, 297, of course, is not an issue on these appeals, but I've gone through the rules, and there are at least 16 or 17 rules which deal with this question. And I imagine that the rules are drafted by different people at different times. Is there any reason to suppose that the drafters of these rules were, like parliamentary draftsmen, poring over the precise wording?
Well,
I mean, that's not how these rules come about, is it? They're departmentally drafted, I suppose, by different people at different times.
Yeah. I suspect that that's right, although I hesitate to give a clear answer. It may be somebody else can answer that rather better. I suspect that that's probably right. Certainly because the changes are added on little by little over a period of years, it's certainly going to be different people. Certainly it's going to be rules which are promoted, drafted within the department itself and discussed. And the opportunity will be there for people to discuss it within Parliament.
And there was a time when there wasn't any lawyer input whatsoever in the rules. I remember it well, but I suspect that time has now passed.
Yes.
But whoever is drafting will have access to the existing rules and can, if he or she is reflecting on how to express a particular point, there'll be some guidance as to how it was done elsewhere. So you get an example like the ones we've been looking at, which you quote at page 32 on your case, where it's very plain that the source from which the maintenance is to come is very limited. So if that's what's wanted, well, there's a good style there which could be picked up and put in the rules we're looking at. Indeed. So it's not a particularly sophisticated point, but it's a point one can make, I suppose, that the package is there to be examined and followed where it's appropriate.
Indeed. And in relation to 297, the way in which this situation has come about is that sometime after Ahmed Ali, a change was made to Rule 297 shortly before the coming into force of the Human Rights Act on 2nd of October 2000. The change was made in Command 4851, which was the document in which, just before the Human Rights Act came in, the Secretary of State made a number of changes to the rules. That's in the Volume 1 itself. But it is that which introduced the words by the parent into into that particular rule. But one wonders whether even that insertion was intended to be, or is to be read to be intended to be, to limit the maintenance and accommodation to be only from the parent, or is it to be read to mean that the maintenance and accommodation is to be provided by the parent, but how the parent actually goes about getting the maintenance and accommodation is another matter.
Yeah.
To be done by the agency of the parent, but the parent can get it from other sources. What those words by the parent are therefore seeking to emphasize are simply the fact that the role of the parent should be regarded in that context as being central. It is emphasizing the role of the parent.
So it's keeping the relationship going.
Yeah, that's right.
Yeah, I mean, that I suppose is the flavour of it, that you want to be sure that this really is a family that is going to stay together.
That's right. And it...
This is the subject of your additional submissions.
That's right.
You say it's a child protection concern.
But there's a different formula in other rules. 303A talks about maintained and accommodated with the parent.
That's right. Yeah. The thing is that it's very difficult to get from those words by the parent in 310 a indication that what the Secretary of State was intending to do was to rule out third-party support, when the other rules on children, including on adopted children and 303 and other rules, do not use that wording at all. All that those words by the parent, therefore, in 297 are seeking to do is, as my Lord Hope says, simply to emphasize that that relationship itself is what is to be kept going. Those rules, as Ms. Castrix says, should all be read as a whole. And if they're read as a whole, there is nothing there in even those children rules to say that third-party support is actually prohibited. In our printed case on this point, what we've dealt with this at page 44, para 103. Some points are there mentioned in relation to MW Liberia. There are others which are picked up in other parties' printed cases, but just a few points there are mentioned as to the approach to in MW Liberia. We make the point that that rule is differently configured. It could be distinguished, but in any event, there are reasons for thinking it was wrongly decided. We make the point about the other children rules that my Lord Collins has just been referring to in 103C. And then we say that the decision of the Court of Appeal in Liberia was reached without knowledge. New rules were being introduced 6th of February, which have inserted new paras 319A to 319K, which provide for the admission of spouses and children of persons here as Tier 1 general migrants, that is, persons here as skilled workers. And in relation to them, there is nothing said as to source or even words such as by the parent. All it says is sufficient level of funds available. And that is set out in tab 8 at the very end. At the last page of tab 8. is Annex E, maintenance funds for the family of Tier 1 migrants. All they're concerned about is the relevant amount of funds must be available.
Sorry, how is this helping? I'm a bit lost.
What we're saying is this, that if this argument is that 297 is focused upon child protection concerns, and therefore the words by the parent are words which actually exclude reliance upon third-party support, we say it is then surprising that the rules do two things. One, in relation to the children of skilled migrants, Tier 1 migrants, there is no such wording that the children should be maintained by the parents, no such restriction. It is all the focus is that there should be the requisite level of funds available.
Sorry, I beg your pardon, carry on.
And secondly, that the other rules relating to children that we discussed with Lord Collins also do not contain that phrase, all of which, we say, points to the fact that the phrase by the parent in Rule 297 cannot have been meant to exclude third-party support, but simply, as my Lord Hope was pointing out, simply focusing attention upon the role of the parent, but not limiting the source of the funds, and emphasizing the relationship that is to be promoted.
I'm sorry, I mean, I think of course I understand that point, but I'm a bit lost at this with the migrant.
Yes.
Because, I mean, of course, if you've got a specific sum and you've got to show it, who cares where it's come from? I mean, the problems of, so to speak, verification and so forth are, long since solved. It's not precarious, the money is there, you can prove it. So, but I don't understand why, therefore, it helps.
Well, the point is it's a specific sum, a specific.
Well, it's doing two things, Mr. Gill, isn't it? One part of it, A and B, is identifying the amount, and then what seems to follow from C to E is who it is who is applying. It must be available to the applicant, but it just says available to, without saying available from.
That's right.
Any particular place. It's just got to be available.
And these are limited sums. They've got to have at least that amount in order for us to be satisfied that we're going to let them in. And we say if you apply the same thinking, same approach to a case under 297 or any of the other children rules, or 281 or 317, apply the same thinking, what is the relevant sum will be looked at by the immigration judge in the individual case.
Sorry, just going back to this last page, C to E, I mean, again, although of course it's talking about, in addition to this and that, we're still talking about specific sums, aren't we? Calculable sums that have to be, so to speak, there, demonstrable as available.
My Lord, yes, but that is not any different to the exercise that is to be conducted under the children rules, under the dependent relatives rules, or the spouse rules. Because under those rules, whilst the rules don't specify a particular sum, an immigration judge will still have to look to see what are the level of funds this family needs in order to maintain and accommodate themselves. It'll have to be a figure. Often it is set by reference to income support levels so that they have at least that level available to them in some form or another. So simply because this page, Appendix C, actually refers to specific sums, and those other rules don't refer to specific sums, doesn't defeat the argument. Immigration judge in those other cases is not looking to see whether you've got £1,600 in funds or £533 in funds, as is mentioned in A and B. What he's looking to see is this parent wants to bring this child over. What are the level of funds that are going to be required to maintain this child or whatever family relationship it is? I think it's going to be X pounds per week. Can I be satisfied that X pounds per week is actually going to be available? That's why it helps, because what this shows is that in a children context, under the children of Tier 1 migrants, provided a certain sum is available, the source doesn't matter, and we say, provided a certain sum, the appropriate sum for the relevant family is available under a 297 application or 317 application or a 281 application. That's what the source is.
But it's a different sort of availability. I mean, the migrants, they've got to be able to show this money is on deposit in this bank with an irrevocable commitment. At least that's what I assume. They've got to show the availability, and the applicant must provide the specified documents. But that's not quite the position under these family provisions. I mean, provided you can show you're in employment and this much is coming in every week. I mean, even if you can't guarantee it'll continue.
It's not quite the position,
no.
But certainly in those other rules, you can't guarantee employment any more than you can guarantee anything else. These sums under Appendix C may be in your bank on one day, they may not be in your bank on another day. The issue is, are people, looking at the evidence before the immigration judge, are people going to be able to sustain themselves without recourse to public funds? And if certain levels of income are available, or certain levels of capital are available to them, that will be dealt with in one way under Appendix C cases. And in the other cases, where there's no set sum as such, it'll be dealt with on a case-by-case basis.
Is there any definition of the expression Tier 1 general migrant? Or does one just take it that that's to distinguish them from highly skilled migrants? The Tier 1 is the ordinary case, is it? And the others are highly skilled?
Highly skilled migrants has now changed. So that this is I'm not entirely sure, but it's a new system replacing for dealing with skilled workers, skilled migrants, and setting them in different tiers. So the HSMP program is gone now.
But Tier 1 has no definition in the rules, as far as I can see.
I'm told that there are criteria for people who qualify under Tier 1, for instance, and we can certainly get those. They're not within reason.
I mean, I think all I'm really saying is, of course this doesn't defeat your argument, but I question whether it advances it, and I wonder if it's really going to be helpful for us to see what goes on with these others.
Well, I didn't want to take any further in that. So far as MW Liberia itself is concerned, we were looking at that.
Well, unlike the Court of Appeal, of course, we're not bound by it.
Absolutely bound by it. It may be worth looking at what the in the way in which.
Well, it was a very distinguished court, of course.
Yes. Tab 45 in volume 5.
Lord, in Lord Justice Saki's judgment, I invite you to look at paragraph 10. End of paragraph 10. reference to the AA case.
Hey, it was Miss Justice Hart, is it?
My Lords, I anticipate your Lordships have read paragraph 10, but Mr. Ford is particularly anxious that I ought to direct your attention to the words and page. It is clear, I think, that when the rule was in this earlier form, the maintenance requirement could be met if it could be shown that adequate third-party financial support was available, because it didn't say anything about who was to maintain the child. Rule change. In that case, there doesn't been a suggestion about human answer. Not suggest this amendment was made for that reason. And then the reference to AA. Some 5 or 6 years later, when upon information provided solely by a Home Office presenting officer, a sea change is then developed in the attitude of the tribunal. No evidence at all. What he said was third-party support, from his evidence, that know that they've been informed by the Home Office officer that third-party support had been relied on too frequently previously in the case evidence, so that support was often not presented to the ECF. Could not be checked. It was said to be a question of child protection. The money to support the child should come from responsibility. That is why evidence to the ECF position. To ensure checks could be made in the UK as the application has been considered. Or as we say, that is simply a question of reliability. If people are not going to produce proper evidence, they're going to lose. They're going to fail in their applications, and that's another matter. And then in paragraph 11, when the judge recited my submissions, including, importantly, in the middle of paragraph 11, says this reflects ideas of family life in a pluralistic society. Well, in our printed case, which I won't take time over to go into great detail, we've drawn attention to the fact that all sorts of family arrangements are now put into place. We are now looking at wider, more pluralistic society. Some people have regarded as a religious obligation even to start to support other members of the family. Family relationships are sometimes going beyond nuclear families, and this is a point that Lord Justice Mumby mentions very well in a case called Pavandeep Singh, which is in the authorities' bundle.
Sorry, have we extracted all we're going to get from MW?
Well, we've got to look at paragraph 13, haven't we, which is really the key paragraph on interpretation.
That's right. Paragraph 12, he recognises the purpose of the rule is no doubt to allow entry in order to promote family life between parent or relative and child without recourse to public fund. And at 13, then he says that the words by anyone else. But that, for the reasons we've discussed, we say is a too narrow a reading. It's not a reading which is consistent with the purpose. It's not a reading which is consistent, indeed necessarily consistent. It's not required with the language. It's not required by the language. When he says over the page, 4 lines down, the parent is unable to do so without recourse and is merely acting as a conduit between the donor and the child. That is to diminish the importance of what a conduit is. To simply label something as a conduit is to suggest it has no particular purpose at all. If that person were to fall out, the arrangement would somehow continue. That's not what this sort of conduit is. Well, this is simply an exercise in labels, whereas one ought to be looking at is what is a substance. The substance is that the parent is able, from the donor, to get funds. The parent is therefore central to that arrangement. It's not a case of the other party being ready to support the child, even if the parent were not in existence. So to label it as a conduit simply fails to analyse the sort of situation that is there properly.
So how do you label it or describe it?
We say that one should look at the substance of the arrangement to see whether the parent is actually, through his agency, through his acts, doing what he needs to do in order to provide for his child. And he is. If he's getting it from, I don't want to put labels on it, if it is the case that he is getting funds from a third party, might be a rich benefactor, might be someone who's set up a charitable institution, might be Save the Children Fund or something like that. Are payments from those sort of agencies to be ignored, to be left out, even though there can be absolutely no child protection concerns in relation to those sort of agencies. The need to protect the children of one's relatives in some contexts, in some societies, is seen to be particularly important. What the rule is, what may have been behind the comments that were made by the presenting officer, which is at the top of the previous page, is, look, we as a department have some concerns about arrangements whereby parent brings in a child from abroad, but rarely the child is at the beck and call, at the behest, under the control of some other person who's actually providing the monies, and this could, one doesn't need to elaborate what the examples would be, could give rise to some concern. But that, we say, is a matter of being cautious and being assessing the arrangement very carefully. That is not a basis for saying that the third-party support in all circumstances is to be ruled out. It may mean that third-party support has to be, in a child's case, has to be looked at particularly carefully. If it's a rich uncle, you may want to have evidence from the rich uncle. He may have to come before the immigration judge, usually would have to, otherwise the case probably wouldn't stand much of a chance if you didn't hold that person. He'd be cross-examined, and his documents would be investigated, his past relationship with the child would be investigated. If there was anything untoward in that relationship, there could even be a adjournment for a social services report.
But hold it, I mean, that's on appeal. I mean, I know, but I mean, one should have some thought, should one not, to the initial decision-making process by the Secretary of State as to whether this leave, or the immigration officer.
But all that, my Lord, you say that's on appeal, but that's precisely what happens in adoption cases before ECOs. ECOs will say, right, I can't actually investigate all this here. What needs to happen is there has to be a family visit report in the UK. They send the request to the UK. Social services get involved. That's why adoption cases tend to take a bit longer. It takes time. But this happens, and I've done a number of them in relation to Indian adoption and so on. That sort of thing is perfectly normal. True, it imposes certain additional burdens. I don't deny that for a moment. But those are burdens in an adoption context which we are very ready to take on. Why not? Why are we not ready to take them on in the case when it's your own flesh and blood, and it's your own child? And what you're saying is that I can actually maintain my child, but I don't actually have the money earned through my own hard work, but we've got a relative who actually can do that.
You're saying, well, if that is the situation, so long as the parent can be assured that he can get the support of the relevant, then the parent is going to remain central, as you put it, to the arrangement anyway. And to say he's a conduit is really diminishing the importance of the fact that he is central to it, because the whole point of the entry process is to reunite the child with the parent.
Quite so. All the protections in the adoption cases, there are rules on adopting children, all those are actually dealt with at the point of initial decision making and at the point of appeal.
Are you saying here that a parent maintains a child if the parent makes an arrangement with a third party, which provides the income. Is that what you're saying? However that income comes to the child, is that right?
In short, yes, but the reliability of that arrangement...
Yes, no, and of course, the reliability is a different matter, but I'm just trying to see how one fits it into the words of the rule, because obviously one has got to do so. So you've got to say, in what sense is this child being maintained by the parent? And as I understand it, you're saying, well, if they make an arrangement, that can amount to maintaining the child.
That's right. You make an arrangement with a third party that the funds are going to be available, and they're going to be available without condition, and you can do with them what you will, but it is understood that it's going to be used to look after the child. That may be what prompts the donor to give the money. That arrangement, provided it is a reliable arrangement, is an arrangement which enables the parent to actually then maintain the child, because the parent is then facilitated in order to maintain the child. Maintenance, of course, involves a composite quality. It can be financial, and in this context it is looked at in financial terms. But when one talks of maintaining a child, one is maintaining the child not simply in a financial way. One is promoting the family relationship as well. So that this maintenance definition in 297 has to be fed into, looked at in the context of the overall purpose, which is to promote this family relationship. And if the reality is that I suppose it may possibly be said, to deal with my Lord's point, that if you're getting money from a third party, but rarely the money isn't being used at all in order to promote the family life, so the maintenance is not occurring in the context of a promotion of family, but that isn't really the maintenance that we're talking about.
I mean, so I understand it, Mr. Gill, am I right? It is accepted here that actually the parent may be being entirely maintained on public funds, and provided only that by the child joining, that isn't going to increase the level of public funding required, that's acceptable.
Yes.
I'm looking back at Rule 6A?
Yes.
The rules. So, I mean, if you can say that this child is being maintained adequately by the parent with money from the state, provided it's not going to need further recourse onto public funds, I mean, why on earth can't you say it can come as well from some other body?
Precisely. I mean, it is not in dispute in this court that disability living allowance can be used in order to provide...
That was in dispute, was it, originally?
No, I don't know whether it was or not.
But it isn't, but now it's accepted.
It's certainly the jurisprudence of the Court of Appeal, not appeal to this House.
It stands to reason the money's got to come from somewhere. One is talking about cash in hand, ultimately, which the parent has got and can buy the food or whatever else needs to be provided. And it could be from paid employment. It could be from benefits, yes, which are not excluded.
Yes.
It could be from charity and
yes,
various other sources. And so far as appears, the frame of the rule doesn't seem to trouble with where it comes from, provided the parent is going to accept the responsibility of maintaining the child out of whatever resources the parent can find. Does it seem that that's the way you say it should work?
That's the way we say it should work.
It's just the natural use of language in a context both in 281 and 297 where the family unit is being kept together.
That's right.
Which would explain the difference between the wording in those and in 317.
Yeah. That's right. And the two rules, accommodation and maintenance, were collapsed into one for 297. And this may have had an effect on the way in which the language was then collapsed together, hence the use of the words by the parent. Those are the points in relation to...
I mean, there is perhaps this, President, that, I mean, if you're right, really the words, let me get this right. I think the point put against you is that you give no meaning to the words maintained adequately by the parent. But your point is that if they're right, that gives no meaning to the words without recourse to public funds.
Well, my lord, the rules, 317, for instance, quite capable of putting in qualifying phrases. In three places it puts in qualifying phrases in relation to accommodation, occupy exclusively, in relation to without recourse to public funds. They do not put in any qualifying phrase at all into 3173 or 3174A, that funds should not be from some other source. And if their approach is right, then one wonders why those words, without recourse to public funds, were emphasized in the way that they were, and yet there was no reference to words such as without recourse to funds from third parties. It is not a natural reading of the rule to read it in the way that they suggest. My lords,
I'm sorry, I'm being extremely inarticulate, I recognise, but just going back to 2815, I mean, one or other of these phrases is tautologous, isn't it? I mean, or it is tautologous, that is to say, because you don't need one or other part of it.
Yes.
Is that right? I think that's probably right.
well, my lords...
I mean, it could just say,
Not have recourse to
it
public
could just
funds.
say, so long as you aren't going to
Don't
have recourse to
yeah,
public funds.
Exactly, could.
But in a way, the fact that that's there suggests that it does contemplate that to maintain themselves, they would need to go to some third party to obtain support, to obtain the money. And the one thing that's ruled out is the recourse to public funds. You could have recourse to a charity. That's not struck out. Or some other source. But the fact that it's there, you could say, wasn't actually tautologous, because it's actually identifying a particular source from which you cannot derive the wherewithal for the maintenance.
My lord, yes, I see that.
Yes, it's all it's saying, you say, there it is, you've got to be able to keep body and soul together, doesn't matter from where, so long as it's not from public funds. And actually it can be from public funds, provided it's not any more public funds than they were going to be expending anyway.
That's right.
Well, would that be a convenient point at which to break? How are we getting on, Mr. Gill? We're nearly through
My
your
lord,
argument.
I anticipate easily finishing before 3. The 2 points are AM's individual case on Article 8 and VS's individual case. But it may be that I perhaps only need about another 35 minutes or so.
Yes. Very well. Well, we look forward to seeing you at 2 o'clock.